On your same scenario, could you fractionalize ownership of that multifamily? 16-unit building, break it down into 4 separate units.
Yeah, here's what I think you, I think one approach, let's say you had an apartment complex that had 4 buildings with 4 units in each building. I mean, it'd be kind of a hassle, but one thing you could do is you could condo it. All right?
Yeah.
You could condo it, and you could have each building, each 4-unit building be a separate condominium unit. Okay? Each condominium unit comprised of 4 apartments. Okay? And I think you could take the position, at that point in time, you take the position that each is a 4-plex under state law, and therefore each qualifies for that funds exemption.
Have to be separate buildings though? Because I've got one that are all together, and I just break them into condos.
It wouldn't have to be separate buildings, but I think you would have to condo it. I mean, I think you're going to have to get it down to single-family residential of 1 to 4 units legally. Yeah. Yeah. All right. I'm not going to spend time talking about the venture capital fund exemption. That's a little crazy. So on the exemption paper, if you qualify for an exemption, when you set up your LLC, you got to file an exemption application with the state of Tennessee, and you got to file an annual exemption renewal form with the state of Tennessee. I will tell you, my advice to you is have a good CPA, make sure they understand what you're doing, and get them to help you with the annual exemption paperwork. And whatever you got to pay them a couple of $100 a year, it's worth the money. All right. All right. So we talked about one of the things that we're stuck with, which is taxes. Now we're going to talk about the other thing which we're stuck with, which really informs our decision about what kind of entity we're going to use, which is liability. So we talked a little bit about this already. General partners, everybody's jointly and severally liable for everything. So, I'm going to put a question to you. So let's say, tell me your name again, I'm sorry. Paul. Gail and Paul and I are in a 3-person general partnership. Now let's say that Gail and Paul are in a 2-person general partnership. And they've gone out, they bought an apartment building, they bought $1 million, they're jointly and severally liable for the $1 million. And then they want to bring me into the partnership as a third partner. I'm at 33% interest. So they bring me in, they admit me as a partner 2 years after they closed on the original loan. Okay? And I, as a general partner, I'm fully jointly and severally liable for everything. Am I jointly and severally liable with Gail and Paul for that $1 million loan when they admit me?
Yes.
Yes. Trick question. The answer is no. Okay. And so here's the deal. Okay. You are not personally liable jointly and severally for pre-admission partnership liabilities. In other words, liabilities that were on the books before you became a partner, you're not personally liable for. Okay? To view it a little bit differently, whatever capital you put into the partnership is at risk for those liabilities, right? Just in the same way as if it were an LLC or a corporation. But the creditors who are owed those pre-admission liabilities can't come after you personally just by virtue of the fact that you're admitted as a partner in the partnership. So there are 2 solutions to that, okay? Because Gail and Paul probably want me to be on the hook with them on this mortgage if we're doing this, right? And so the solution to that is, as between Gail and Paul and me, they're going to want me to sign a partnership agreement where I contractually agree with them in the partnership that I am jointly and severally liable with them for everything, and that if one of the partners bears more than his or her pro rata share of the mortgage debt, the other partners will each, reach into their hip pocket and pull out and throw in their share, right? So that nobody's going to bear more than a third. So they're going to they're going to contractually make me liable just like they're liable, right? And, it's also possible that if they have to go to their lender to get permission to admit me as a general partner, the lender may require me to sign a guarantee, okay, that is going to make me contractually obligated. So I may end up at the same place when I have to sign some pieces of paper to get there. It's a good thing to remember if you're in a general partnership, right? Which also is sort of, I've had deals where it involved loans to general partnerships, and the bank has required the general partners to sign guarantees, and the general partner said, "Wow, what's this about? I'm already liable as a general partner. Why have I got to sign a guarantee?" Well, the answer is because under the general partnership law, a creditor of the partnership must first exhaust the partnership assets before they can go after the partners personally. Okay? By exhaust the partnership assets, it means, in this example, they have to go out and foreclose on the apartment building, right? Get whatever they can get in the foreclosure sale, and then if they end up with a deficiency, at that point in time, after they've exhausted all the partnership assets, they then can come after you for the deficiency. If the bank wants to have a path directly to your pocketbook without having to pass go and foreclose, they're going to have to get you to sign a guarantee. Okay. So limited partners have limited liability unless they screw it up. And they can screw it up by acting like a general partner. So with a limited partnership is going to have a general partner, it's going to have limited partners. The general partner is responsible for managing and running the limited partnership. And that general partner is the general partner of a limited partnership is fully liable for all the partnership stuff, just like the general partner of a general partnership. Okay? And if you've got two general partners of a limited partnership, they're all liable just as if it were a general partnership. The limited partners are not personally liable unless they act like general partners and they participate in the management and control of the limited partnership, causing third parties out there who are doing business with the limited partnership to think that they're dealing with a general partner, right? So the idea with a limited partnership is if you're just passive, if you're just putting in money, if you're just an investor, if you're just getting a check, and if you're not trying to run the show, if you're not causing third parties to think that you're actually a general partner of this thing, then your limited liability protection is going to be respected. All right? But if you, and there's a list of things that you can do without subjecting yourself to personal liability. But if you step over the line on one of those, you can end up getting sued personally, which to go back to the gentleman's question a few minutes ago, which is why we don't use limited partnerships that much anymore. When I first started practicing law, the real game in town on sophisticated real estate investment, they were all limited partnerships. Okay, we did limited partnerships all the time. We didn't have LLCs. The number, for every 99 LLCs that I see maybe one limited partnership, and maybe not that. I mean, it may be more like 999 to 1 at this point in time. Because why subject yourself to the brain damage of having to worry about ever doing a foot fault as a limited partner that's going to subject yourself to liability when you can get to the exact same place you want to get to as an LLC without having those issues. So the liability of LLC members is totally limited like corporate shareholders, okay? I mean, the law of the land, if you look at the LLC statutes, your liability as an LLC member is limited just as if you were a shareholder of a corporation. You do have, and you see veil piercing up there. By veil piercing, I mean, what are these circumstances under which a creditor of a corporation or an LLC can pierce the limited liability protection of the LLC or the corporation and come after your assets personally? You have veil piercing concerns with LLCs just like you have with corporations. That's a whole separate presentation. I will say Tennessee is not a particularly favorable state towards plaintiffs who want to pierce LLC and corporate veils. The law is pretty favorable. I mean, you generally have to, I was having this discussion with someone today, if you have an LLC and you do a reasonable job of observing the formalities and you're not a bad actor, you know, I think the odds of a judge allowing someone to pierce your LLC veil are pretty low. Okay, where you see, you know, where you see judges allowing someone to get to LLC owners' assets personally or corporate shareholders' assets personally is what you read the case, and regardless of what they say, you can tell that what they concluded is that this person is a jerk. All right, and they've been out defrauding people and screwing people, and it's a bad outcome, and we're going to figure out some way to make them pay. But avoiding absent circumstances like that, you should be fairly confident that you're going to get your liability protection. So I will say a way to screw things up. This is on the pre-formation down here. A lot of times, I may get a call from a client say, Richard needs to set an LLC up, we've got a new real estate project planned, we're all excited about this, and I'll say, that's great, when are you planning on putting the property under contract and buying anything? Oh, we've already bought the property, we've already signed the contract, we've already closed on the loan. Well, yeah, that's awesome, all right, but, and I'm happy for you, but everything that you just signed before the LLC actually came into existence, you're personally on the hook for, okay? So let's say you know you're going to call it Acme LLC, and you just ain't gotten around to forming it, and you signed the contract Acme LLC, okay, by John Smith, president, okay? Well, you signed the contract knowing Acme LLC didn't really exist. You're personally liable for it, okay? And in particular, we also see this a lot with leases, where people, when you have new business, they're negotiating a lease, they know they got to get that new business set up, everything, but all of a sudden the lease falls into place, the landlord sticks in front of them, they want to sign the lease, and have the LLC set up, it's a problem, all right? There are two ways of dealing with that. The best way of dealing with that is set up the freaking LLC before you sign the piece of paper, all right? That's the best way of dealing with it, okay? The second best way of dealing with it is probably still okay, but not nearly as good as the first way, is if you know you're going to set it up as Acme LLC, and you sign it, Acme LLC, a to-be-formed Tennessee LLC, and you clearly disclose to the other party to the contract that the LLC is going to be formed, but has not yet been formed, that should be respected. But that is not as good as the alternate.